I'll hand over the stage to Carmi to say a few words. At the end, we'll hold a short Q&A to wrap everything up. I'm joined now by Linda Tialova.
Thank you so much, Journey, and thank you so much for having me. So my name is Linda. I'm a privacy counsel lead with a software company which is called OneTrust. What we do is that we help businesses operationalize and manage privacy, security, and compliance risks. So a lot of things that hopefully put together help the business build sort of ethics and trust type of relationship with everyone involved. And my role with the company is that I'm responsible for privacy compliance internally, but more importantly, my team is also helping to build the content into the software platform, like templates and guidance to help businesses comply with the GDPR and the privacy side of things, but also other things like security and risks tracking. But yeah, so this is me, I guess, in a nutshell. Thank you so much for having me.
Great, welcome, Linda. We're happy that you could join us. And we're also joined by Preston Bucati. Preston, do you want to give a quick introduction?
Yeah, thank you. Thank you. So my name is Preston Bucati. I am a compliance attorney for a company here in the States called Untitled, and we are in the business of telecommunications. So SMS text messaging, phone calls, phone routing. In fact, you know, when you dial into Zoom and call phone numbers, there are companies like ours that route them all behind the scenes and make sure you dial into the right spot, and also trying to help with a lot of the robocalls and spam that people get nowadays. So as you can imagine, our business privacy is very important, not only in the transferring of information across jurisdictions, but also that personal aspect of people's messages, their communications. And so it's a business to business. It's not quite as, we're not Facebook, but we are engaged in a lot of personal data. And so this compliance stuff is of the utmost importance, and we're trying to stay on top of the evolving regulations in this space. So I'm excited to talk more about this because I know I have a lot of thoughts.
Great, thank you, Preston. And we're really happy that you could be here as well. Carmi, do you want to do a quick introduction?
Yes, I'm not a lawyer. Sorry. I'm like the rest of the panelists, and I guess data compliance is covered by regulations and standards, which I hope the esteemed colleagues on the panel will be able to deal with that. Hub security provides technology that helps people enforce and protect data protection. So, we're sort of about rolling up your sleeves and getting the protection done versus the paperwork or the standards part of it. And we do help companies comply with the standards. You can't really comply without the technology. So I'm very also excited about this panel, and I think that you said we'll open it up. So normally when we open up, we have a few presentations, but I really don't have anything to present because we said that we were gonna do this as a Q&A session. Mm-hmm. So I'm going to go right over to Sterny and say, Sterny, start firing away with your questions.
Great. Thank you, Carmi. So yeah, we're going to have a bit of an open discussion today. I'll throw you guys some questions. Feel free to jump in and give your 2 cents. And we'll also leave some time at the end for Q&A. So if anyone in our audience has questions throughout the discussion, you can drop them to Q&A. We'll try to answer them maybe as we go, but we'll mostly get to some of them at the end as well. So don't be shy and feel free to engage. So I guess I'll just start with our first question that I wanted to ask you guys, which is, what are some of the newer privacy laws out there globally, and how are they different from the current GDPR laws that exist?
Right. Shall I maybe start, and then I'm sure Preston will have a lot to say about that as well. So I guess from like a point of view, very, very broad point of view, the privacy laws are right now quite a big topic pretty much globally. I think what GDPR has started was this sort of massive privacy wave where we are suddenly seeing most of the states respond in one way or another by either upping their levels of privacy laws or even like going out to actually embrace a comprehensive privacy law. So the example of state that just like turned around and came up with a privacy law would be California, the CCPA, and also in the future, the CPRA are really interesting take on privacy, because they're slightly different from the GDPR, actually quite different from the GDPR in a few concepts. So California in specifics, I think if I were to highlight one thing that is really different as opposed to the GDPR, it would be the idea that you actually have a certain value, almost monetary value, which is assigned to your personal data. And you actually have the ability to sort of enforce that value as an individual. And so you have the right to opt out of reselling of your personal data. So if you give your personal data to some business and they then go on to resell it to other businesses for marketing purposes and whatnot, you actually have the way to say no to it. And optionally, you can actually say, yes, I want my data resold. And it is sort of expected that there's going to be some sort of tit for tat, some sort of payback from the company in terms of maybe offering you like a premium type of service if you say yes to the sharing of your data, and you basically getting something back in return for your personal data sharing. So I found that concept really interesting, something we're not really seeing with the GDPR, but obviously there are plethora of privacy laws out there that are just popping up, and most of them I would say are sort of built around the blueprint of the GDPR. So particularly, let's say in Brazil, the new LGPD law is very much like the GDPR, but maybe like compressed into, instead of like 300 pages, you're looking at 60 pages. But definitely a lot of inspiration around the world from the GDPR, which I think is good in a way because it doesn't put you in a spot where you have to do things completely different based on which jurisdiction you're based in. But there's always going to be those nuances and the changes between one state to another and the way they interpret these things, like the way they interpret specific rights. So I think that's where the devil lies really in the detail with these global privacy laws. But I'll be really curious to hear Preston and maybe his take on some interesting, significant privacy laws out there.
Sorry, I had myself on mute. So Linda's right. I have a lot of thoughts, and I would agree a lot with what she said. I think what's been interesting here in the States is, and not to make it too political, but since our recent change of administration, I think there is more of an opportunity for lawmakers to pursue regulation in this space. The previous administration claimed to be a little more business friendly, whereas I think this one would be more in favor of consumer protection. And that's really where the US has come from this topic. The CCPA is mirrored off the GDPR. I think there's even a lot of language that has been lifted straight out. And the CCPA is serving here as sort of like the groundwork for what other states are doing. Because, hey, if it works in one state and nobody complains too much, and then maybe it will work elsewhere. But to that end, obviously here in the States, we've got all different cultures and peoples. So new states are coming out with laws. I was reading this morning, there's something like 20 US states that have proposed legislation in this space. I know that Virginia recently passed one that is similar to the CCPA. One of the big differences is that it would allow people to opt out of targeted advertising. Specifically, it says targeted advertising. So I know that's throwing my marketing department for a loop. And then the other interesting one I've seen, right, there's other states. I was reading this morning about Florida and Washington and Texas, but there's one that's going through in Oklahoma. And the interesting thing about that is it would potentially require consent to collect data, and not just sensitive data, not just that's one of 6 legal bases. It's you would need consent to collect and process data. So it's been kind of interesting, I think, in the States, because I think we have taken a stripped down version of the CCPA, and now there's all these laboratories in each state coming up with their own slightly modified version to see which one is best. And the thing I will leave everyone with is last year, before the pandemic and we were all locked down, I was lucky enough to attend an event hosted here in Denver, Colorado, where I live. The state attorney general was having a small business event to try to facilitate business input on these laws. And my opinion is that they are trying to see if businesses or industry will find a solution. I feel like our governments don't want to set the rules. They sort of want to set guidelines and let people figure it out. So it's a little bit more of a struggle. There's not as much clear guidance. There's not as much help from regulators like the CNIL or the ICO or others. So I consider us a couple of years behind, but we're catching up and we're figuring it out.
Great, thanks guys. Thanks to both of you. What do you think are some of the legal issues? Because we have a lot of lawyers in our audience right now. What do you think are some of the legal issues to consider when thinking about these various laws?
Definitely, there are so many. I just wonder which ones to begin with. But very often what we find is something that Preston mentioned there earlier, the idea around like, what is your basis for processing the personal data? Why are you actually supposed to hold on to the data? As Preston mentioned, sometimes it would be like the states and the laws almost fixating on the idea that you always have to have a consent from the individual for basically handling their data in one way or another, which is not always that convenient. Sometimes it will be just the idea that you need to give them some information about the processing, but the fact that you need it either to, I don't know, sell them something or to fulfill your own obligation in one way or another would be enough. So there would be the difference in like the legislation's perception of how you're supposed to actually handle the data, why that is. Also, I think some of the key issues around it would be the idea that we still have some sort of unclear or divided view between the US and the rest of the world almost around what is sensitive data. So for the US, it would very often be the data that is involved in identity theft. So the data that allows you to basically steal someone's identity, your, I don't know, passport number, social security, and so on. Whereas the European perception of sensitive data or special categories of data, as is the new term under the Gdpr, would be the situation where it would be the data which really could harm you even emotionally or as a person, as an individual, if stolen. So it could be your sexual orientation or information about your medical state. So things which are not necessarily translatable into identity theft. So that sheer differentiation between these things could be an issue on the practical side of things where businesses actually have to treat the data differently under those laws. And if you're operating globally, you're basically looking at two different buckets of data, but you have to treat them in a very specific manner. So those would be some things, but I'm sure, Preston, you have ideas around what would be some other issues that come up with these privacy laws.
Yeah, no, thank you, Linda. And I would say I'll kind of give my perspective on stuff I've been thinking about. One of the things that's very kind of top of mind here in the States is we've, you know, as a nation been going through this discussion around racial issues and equity. And to that end, a lot of businesses are working to facilitate diversity and inclusion, and which is a great thing. But that also, kind of to Linda's point just now, involves collecting a lot of sensitive data around race, religion, sexual orientation. And it's been very interesting to see a global business try to approach this, you know, maybe a human issue, but as you can imagine, these topics are very culturally dependent. And so when I'm asking employees in Germany to give me their religion, they're not very excited to do that, right? And then on the flip side, you know, there's all those, so that's been an interesting thing to work through. And I think that drives me towards this development in US law where I am seeing states start to carve out, much like the GDPR, a difference between sensitive or critical data and then the more normal stuff. And my impression is that US law so far is going down this route of, you know, hey, if you're processing data for normal stuff, you know, for example, employee administration, that is not really what we're worried about. And so you see exemptions like that appear in laws like the CCPA, where it says it's explicitly not directed at employees or business to business relationships. It's really more business to consumer. You're seeing laws like the New York Shield Act say, hey, there is a set of rules that apply to personal data, and there is a separate, more stringent set of rules that apply to sensitive data. And the thing that's interesting is, where is that line, right? Some people think geolocation is not sensitive. Would you let me follow you around all day, every day for a week? So, you know, we're seeing different states approach that differently. Like, I think I was reading this morning that Texas, their proposed legislation would maybe require consent in order to collect geolocation, whereas that is not an issue in California. And then the last thing that's top of mind, dragging over from last summer, is the SHRIMS issue and international transfers. I'm curious to see where this conversation goes because, again, with our change in administration, I think we will have better international relations, or at least that's the hope. And whereas under the previous administration, I don't know if that was going to happen. So it's this approach from my perspective of, hey, different countries are recognizing the economic, military, business. They're recognizing the value of their data, and they're saying, hey, we can't just send this all over the world. We need to protect it, secure it, know where it goes. And so my question is, how do we do that as a global society? Do we all agree to the same rules, which is complicated and difficult, or do we have separate internets, right? If you're in China, do you not have access to the same websites that you would in Czechoslovakia, right, or Connecticut? So those are all things that I know we've been thinking about. It's just this managing of how do you deal with all these different laws at the local level with a broader compliance paradigm, because at the end of the day, we all use the internet and we often all use it quite similarly. So, like I always tell people, a good password is a good password. Doesn't matter what language it's in. So we're all trying to find out what is good privacy and what data is worth protecting and what data can and should be shared.
Definitely. And I want to get Carmi's input on security aspect of all this. But before we jump to him, I wanted to ask you guys, how has the GDPR set the tone for international privacy law? And we can see maybe other countries are copying it, but in what ways?
Right. Maybe let me just sort of answer that by piggybacking on what Preston has said around the data transfers, because I found that really interesting. I think what the GDPR has really set the tone for is the idea around, we are not going to let just every state get the data outside the EU. We need to set some sort of boundaries around what can and cannot be done in terms of taking the data for the state's surveillance purposes. So every time we sort of transfer the data outside this sort of implicitly safe zone of the EU/EEA area, or basically that sort of internal market, we need to make sure that the data has some sort of, some sort of protection. And I think what is really interesting with this is that the GDPR literally set the tone around what is the level of protection, and they almost like started creating this club of adequate countries where you can transfer the data and have it flow very, very freely without any additional safeguards. And they used to be also the US under the privacy shield to an extent. So now that one is away, and it seems like what the EU has built is almost this idea of a political race to set your tone for what is supposed to be safe country, what you can or cannot do with the personal data, how your surveillance is allowed to access the data or not. So I think what we might be seeing down the line, except for just the copycat content of the privacy laws, is also the political element of it, where the states might start to build their own islands or clubs of fellow states where the data would be flowing freely. So it's not the idea that we would have a situation where the data being completely localized in one state, but I'm kind of thinking personally that we might see the idea of a few legal regimes, like with the clubs of states sort of being surrounded globally. So that's what I see the GDPR really bringing to the table, maybe on the more, I don't know, geopolitical perspective, I think.
I think for me, I see a lot of the controller processor distinction, right? Like to me, the GDPR has sort of outlined the contractual relationship between companies. And that to me, I think is going to be the interesting thing in the US, because I think a lot of law in this area will come about through litigation. And ultimately that will be, hey, party A had a data breach, party B is in front of the regulators, who's got to pay the bill, and that will come down to contracts and DPAs. So similarly, right, like you think of the EU model contract clauses, that's another thing that to me has really solidified this relationship of who is importing data, who is exporting, and what are the primary responsibilities, right? Again, California's law, Virginia's new law, they're all following in that model in the sense of one party is a data controller. It's the party that determines the purposes and means of processing. And then the other ones are service providers, they're processors. And so in turn, some people have a lot of compliance obligations directly with data subjects, and others are more that back-end business kind of connection. So I think that's what's been interesting. Certainly a lot of countries copying similar language, right? Like you've seen that Brazil, I think it's LGPD, quite similar. And again, right, if you're a nerd like me and you read these US regulations, they're just copying and pasting from the GDPR. It's almost like, man, I don't know how it just seems sometimes it's like, wow, it takes them months to write this, but I'm like, I think you just copied the GDPR. What took so long? So it's interesting to see that, and I'm curious to know where that goes, because for the most part, that's been very easy, right? One party has data and they give it to someone else. But what about those more complicated situations where there's a joint controller model? I think that's where, like, I'm still looking to the EU, because I don't feel that many of the organizations I've worked with here have thought through that. They're just sort of thinking linearly. There's party A, then party B. But what if you both use the data for kind of your own uses? How do you split liability? So I know I'm anxiously awaiting the new updates to the model contract clauses and the business obligations around that, right? Indemnities, liability, and all that kind of the more boring lawyerly stuff, but it's the expensive stuff if you ever have to go to a courtroom.
Definitely. And I wanted to get Carmi's take on this. Is complying with standards enough to protect confidential data?
My view is, well, in general, standards are normally the lowest common denominator agreed upon by a bunch of bureaucrats and lawyers. That's how you get a standard. You don't go to the best technologist and say, how do we protect this stuff? That's just not the way it works. So if you look at where a standard comes from, and by the way, it has to be agreed upon. I'm not judging it negatively by saying that it is the lowest common denominator. For people to agree, you need to hit an agreement, which in many cases is the lowest common denominator that they'll all agree to and agree to enforce. So standards are the stuff that you have to have, and to comply. And obviously, if your service provider doesn't comply with the standard, then in my view, they're not giving you the minimal amount of protection. But to answer the question, is that the maximum amount of protection? No, by far, it is not near enough. Certainly to protect the finance, it could be enough to keep you from getting sued, but it's not enough to protect your data. The interesting thing is that the Washington Post said that in 2020, over $1 trillion were stolen, or that's the value of hacking. $1 trillion, and that's an estimate. It's a very rough estimate. And so, obviously, our company is here to not only help you comply with the standards, but help you get much further than the standards. One of the things that I wanted to talk about, it was actually a case that Preston just alluded to, which is sharing of your data between providers. If you take your medical records, obviously those things need to be kept completely under control. So if you took an MRI in a hospital, you would want to make sure that a person approves that MRI only stays in that hospital and only gets used when you want to use it. But if you want the medicine to progress, you'd like to do machine learning and data processing on that data so that you can get better medicine, so that you don't get, so medicine can go forward. And only that, you'd like hospital A and hospital B to be able to share your MRI and still comply so that you can get a better data set. Because I don't know if it's clear to all the lawyers on the call, but the more data you have from machine learning, the better the results. And so the more you let the service providers who collected your confidential data share it confidentially and securely in order to enable better machine learning, the better it is for humanity. So this is the type of technology that we actually provide. We provide technology that lets companies or hospitals stay HIPAA compliant and yet share their data to enable better machine learning. This is the type of areas that we go into. So, so back to the beginning, is standards enough? No, you have to comply with standards. And our job is to help you comply with standards and to stop standards from inhibiting advancements in data processing where they could be useful.
Thank you so much, Carmi. I want to piggyback off of what you guys, the last point that you guys were just discussing regarding business approach to data sharing, and also regarding the differences within different jurisdictions. So how do we rationalize the business approach when it comes to compliance between different jurisdictions around the world?
Right, maybe if I can jump in, and obviously I know Preston and Carmi might be able to follow as well. So I would actually echo what Carmi mentioned there, that the standards can be helpful because they provide you this sort of common denominator for what is mandated. It's obviously not the best in terms of like the best that you can get, but it's the type of thing that I love how Carmi summarized it, is the thing that will prevent you from going to court. So I think the standard is actually a really good way of looking at it, also from the privacy perspective. So there are actually some standards already out there which build on the privacy common denominator across the jurisdictions. So one of them would be ISO 27701, which is the extension to the security operations one, to the 27001. So for that one, I think it's actually a really good one to sort of start with, because it is tailored to be closely aligned to the GDPR, and it is looking at your compliance and operations through the lens of security, but it's adding that privacy layer to it. So you can sort of start with it as your sort of global standard, and then you can sort of stack it up against the jurisdictions and the laws where you're operating, and you're just going to be sort of focusing on the odd things which don't really align. So it's not going to be a situation where you have to start building your privacy program from the ground up every jurisdiction that you go in. But let's say for Brazil, as Preston mentioned, it is a carbon copy of the GDPR. Same thing for CCPA. There are many commonalities with the GDPR, and also by extension with the standard, the privacy standard. So this way, I would say being able to capture what is common versus what is different, being able to track that, and potentially, if you translate it into that sort of risk language, assign risks, assign risk mitigation plans, assign people who are responsible for mitigating these things, and tracking those risks over time. That is, in my head, sort of a good way of tracking these things and tackling globally the privacy challenges. And just one more thing, I really love what Carmi said with the standards and needing to build beyond that. I think privacy has exactly the same mentality. So you could have those standards, and once you're sort of on par with what is needed based on those standards, you can build beyond that. And that's what's actually called privacy by design. And based on what Carmi has been describing with the product, the Hub Security product, that is literally what we're aiming for as well, being able to build something that ensures that the data is private and that the privacy considerations and individuals' rights are taken into every step of what you're dealing with the product and the operations. So the idea behind, let's make sure that the data is confidential, only the right people have access only to the certain scope of the data, that's literally privacy by design. So I think there are actually many commonalities between security and privacy there as well that you can build on as well.
Yeah, my comment is, before COVID, we used to travel. I used to travel a lot, and for those of you who used to travel to different countries, you try to plug your laptop into the wall, and it didn't plug in. Why didn't it plug in? Shouldn't there be a standard for how to connect the computer to the wall? I mean, shouldn't plugs just be plugs? And the answer is they should be, but they're not. Countries are different. America even decides it's not 220, it's going to be 110. Why? That because we can. And so while it would be really helpful if more and more countries could come up with the same standards, the reality is that different countries and different countries and even different applications will require different levels of protection to adhere to their standards. And so back to my travel thing, I used to have a little adapter. I used to take out my little box, unzip something, and then use an adapter to plug my European, coming from Israel, power cord into the wall. And everywhere in the world that worked pretty good. In England, it was this huge plug. My God, I have no idea why they're so big. But anyway, but it used to work. And the key word there is not that the British plug is big. The key word is an adapter. And in hub security, we've actually built a data control adapter. In technology, you call these access rules or policy engines. And we have an engine that allows you to define the policy which gives you access to your data. And we don't build it with a rigid policy because we realize that not everybody has the same policy, not everybody has the same rules, and not all data is equal. Certain data needs more protection than other data. Certain data, like Preston alluded to, might not be available. Like a German might not give you their religion. That was his example. And so you need all kinds of adapters. Technology needs to provide the bridge or the gap to cover all the differences in the regulations and in the policies of all the different types of applications, but yet let this work together. The only comment I didn't like was you might have two internets. I really don't think that that's the answer. I think that the answer is one internet where the corporations adapt their data and their technology to meet the regulations of the countries that they're dealing with. And so that they give the right answer in the right place, but they don't have, but it's all out of the same internet with as much commonality as you can possibly provide in this situation.
And I would agree with everything everyone said. And I go back to Carmi's point about standards, and he's absolutely right that they are the lowest common denominator. And it's not that it's a bad thing, but think about how laws are made, right? And Carmi, I love your analogy. I'm big on analogies myself, and so mine, I always tell people, imagine this 100 years ago, and cars are a brand new thing. Nobody knows how to drive them. People are getting in accidents. They're crazy expensive. People are getting hurt. Well, now 100 years later, if I get in an accident, I can take a picture on my phone, I send it, and 30 minutes later, they can tell me who's at fault. The reason that happens is when something is introduced to society, good or bad, we kind of figure out what to do with it, right? And we play with it, and we determine how can it benefit us, how can it harm us, and over time, people start to decide, well, these bad things, we don't want to do that. And so to Carmi's point, that's where the lowest common denominator comes from. It's trying to set a standard that's sort of one size fits all, because governments, frankly, don't have the time to listen to every single individual case and all of the specific circumstances. So going back to cars, right? I don't care if you're driving a Ferrari or a Fiat, you need to go a reasonable speed, you need to have an airbag, you need to have a seatbelt. Is that going to save your life? But it's going to do pretty good, right? And so to Carmi's point, and to Linda's too, there are these commonalities around these laws. I think everybody around the world can agree there's certain data that we are more sensitive to. We want to understand, why are companies collecting our data? What are they doing with it? Are they protecting it? Doesn't seem like it. And so there is a lowest common denominator, at least in my opinion, right now, to comply with these laws around the world, right? You need to have a privacy policy that puts people on notice about what you do. You need to give people access. You need to honor data subject rights. But then to Carmi's point, you need to adapt that for the local nuances, because every country has reached this point differently because of cultural backgrounds and the way things have developed, right? Similar to cars. Different countries have different cars. Some countries drive on different sides of the road. And yeah, to Carmi's point again, hey, in the United States, we do things different from everybody else just because we like to be difficult. So I think what we have to find when we talk about a global compliance strategy, in what I've seen a lot of companies do is take a risk-based approach, right? They're looking at money, they're looking at exposure, they're looking at customer inquiries, and which jurisdiction do we need to focus on now? I think that's kind of all you can do at the moment. But to Carmi's point and to Linda's, it's beneficial to think about those commonalities between the laws, find that common standard and make that your program, and then start to think about the adapters you would need to make things work based on that. Because the only thing I can guarantee in this space is that I think laws will continue to evolve. I'd say we still got 20 more years of figuring out what is data privacy. And so there's going to be more regulation in this space. The rules are going to change. And if you're focusing rule by rule, you're going to spend all your time doing that, whereas you can try to find a global strategy and then improve on it from there with those principles of privacy by design, bolstering your security and all of that kind of thing. Because I've seen a lot of small companies go through this regulation by regulation, and it takes a lot of time and money for them because they're not thinking about it as a global phenomenon. They're just thinking about it's some new rule that I have to deal with. And I go back to my analogy. It's like car safety or food safety. The internet is a beautiful thing. It's given us a lot of great advantages, but now we're starting to learn that we need to control it in certain ways. And so everybody around the world is just deciding the proper way to do that. And then, so the last thing I'll say to Carmi's point earlier, and I think it was mine, I think everybody around the world needs to think long and hard about where do we want to be 20 years from now. Because if the United States, for example, buries its head in the sand and says, well, we won't honor data subject rights in Europe, as an example, we could find countries diverging. And so I think it's beneficial for global leaders to sit down and think about what is this common standard. To Carmi's point, can we find a plug that would work for everybody? Because again, we all use the internet, we all have data, we all have names and birthdays and family members and medical information, and a lot of people don't really like giving that up for no reason. So I think the past 10, 15 years, companies like Facebook and Google have made a lot of money on this data, and now we're seeing governments start to rein it in, just like any other industry, right? First couple of years is crazy, and then the regulations come down to make it safer, better, more productive, and more protective. So we're just trying to figure out what is that standard, and whoever can guess first, you might be able to get some competitive advantage by saving time and energy and handling this stuff now as opposed to every 6 months.
Right. How can we rein in the Wild West of data collection? It's a good question. I want to ask one final question, but I also think we're running on our last 15 minutes, so I would like to leave time for Q&A. So maybe we just keep our responses a bit short, so we have enough time. So my final question would be, how do you guys think you can sell the idea of privacy to business stakeholders, right? Like you said, there's companies like Google and Facebook whose whole business model is built on data collection. So how do you advocate for privacy awareness and for privacy resources within companies?
I'll take a shot at it, and let's see if Preston and Carmi can correct my course. I would say let's really start paying attention to what happens if you're not privacy compliant. And I think the underlying theme is that you lose the trust of your business partners, you lose the trust of your customers, potentially of your employees. So I think if the businesses aim for success, they need to consider privacy. And obviously, I hate the argument of fear mongering and saying, oh, you're going to get fined, because it might not necessarily happen, but what might literally happen is the fact that you mess up because you were not paying attention to privacy. Very similar to, I think, potential issues when you don't pay attention to security. Very, very similar, I think, line of thought there. So I would almost argue that to make the case for privacy, let's really pay attention to how we make the case for cyber and how we make the case for boosting our, I would say, posture from a security perspective. And I think very, very similar arguments could be made for privacy without necessarily just the fear mongering with the fines. But yes, the fines do happen under the GDPR. They are large. I don't want to understate it, but yeah, that would be my argument.
I think it's progress for humans. Gmail, when it came out, was really cool. It was free. And if you read the ULA of Gmail, it said, we read your emails. That's it. We read your emails. Google didn't hide it. They said we read them. And everybody has a Gmail account. Okay. Human beings at that time said, email's free. It works. No limit. Oh, who cares if they read my emails? Let's just go. You fast forward to about 2 months ago, Facebook said, we're going to change the way we deal with your WhatsApp data. And the amount of users on Signal went up by like 200 million. Okay. So I think that the best way for businesses to enforce privacy is, along with their other security, is because it's going to be good for business. Okay. You know, and businesses adapt to things that are good for business. I would say that, all things being equal, we are now moving away from that Gmail, Google reads my email and I don't care, to Facebook, no, you can't change your data. I'm going to go move over to another platform if you decide to switch. And so I think that that trend is becoming more prevalent. People again realize what can happen to them if their data is not private. And so the regulations help, the fines help, but businesses by far are driven by their consumers, always. That's the best driver for all businesses. And I was very pleased to see, although Elon Musk got the signal to the wrong company, forget it, it's really weird. He actually, the wrong stock went up, but that doesn't really matter. But still the signal to noise, which I'm sorry to use that pun, was fine, it worked. And so I think that humans, we're all paying more attention to it. And along with protecting the money, see, the other thing about the privacy and where we come into the picture is that your revenue and your network and your data, then you need good crypto tools to protect your business. You might as well use the same tools to protect the privacy, because it's good for business anyway. And there's really very little extra cost involved there.
Well, great.
I would agree with those points if I can jump in, Sherny. And I'll say this, right? So I agree with Linda, like in my job, I'm not a sales guy, I'm a lawyer. So usually I'm grumpy and I say no, and that's our job, is to come in and scare you, right? So I can show lists of fines. And then the next thing I usually always get asked is, what are the chances that will happen to me? And that's where I kind of pivot more to Linda and Carmi's point, is it's about a question of what type of company do you want to be? These laws are coming, whether you like it or not. And so you can either spend time and money chasing after the fact, rolling the dice that you'll never have a data breach, never get caught, never have to go tell your customers, never have to tell a regulator, or you can just try to do the right thing. And that's what I always tell people. It's like, hey, there's a chance we might not get caught. It might be pretty high, but it's not the right thing to do. And how would you feel if we did get caught? And to Carmi's point, especially, I think that's where I drive this argument home, especially in the States. I find when the GDPR first came out, a lot of organizations here were very much like, hey, what are they going to do if I violate the law? And I had a lot of arguments with people about international treaties and how this would be enforced. But at the end of the day, if your customers don't trust your platform, if users don't want to put data in your system, how are you going to make any money? And that's the other thing too. I try to tell business leaders is, hey, think about this data as an asset in the financial sense. It's valuable to us. So we don't want to lose it. We don't want to give it away. And what's more is we are under an obligation to protect it. If we do not, it would be the same thing as if we admitted that someone broke into our office and stole our computers, or broke into the parking garage and stole all of our cars, or broke into the warehouse and stole all the phones. At a certain point, people would stop doing business with you, right? And I think presumably everybody on the call has seen some of that start to creep up, right? Apple is big in driving home how privacy is a differentiating factor for them, right? You could get a Google phone if you want, or use Apple, and they're never going to look at your data. So that's what to Carmi's point, I think people can use this as a selling point, a brand tool to build trust. And even if privacy is not core to your business, it's something that your business partners will care about because they don't want to be dragged into litigation or in the news. So it's ultimately about being a responsible company in the 21st century, to me, in my opinion.
Right. And for many, the reputational risk is simply just not worth it. But I'd like to quickly move on to Q&A because we don't have much time left. So thank you both, Linda and Preston. And of course, thank you, Carmi. This was super fascinating and relevant discussion, and I'm glad that we got the time to cover it today. I have some questions here from our attendees, and let's try to keep the responses to around 2 minutes each. But this is a question for Preston. How did last summer EU Court of Justice invalidation of the EU-US Privacy Shield impact the regulatory burden for companies which need to transfer EU personal data to the US? And I can paste the question in the chat so everybody has a chance to see it.
Yeah, that's a great question. So I'd say the first thing was the practical implications of just simply switching to this model contract clauses, right? So if you had previously relied on Privacy Shield, you needed to go get all your contracts and update them with new language. Not terribly complicated, right? That's just a bunch of Word documents. But the bigger thing is the continued guidance coming out from the EU around these risk analysis around the transfers and whether data can be intercepted. So to me, it is a lot of companies just went ahead and said, well, we'll sign model contract clauses and that's it. But there's a bit more to it, right? And you have to be able to demonstrate you've done that risk analysis. Is there adequate protection in the country you're in? And I think that's something a lot of US businesses are waiting for more guidance on, because again, hopefully with our change in administration, maybe we'll see a new Privacy Shield or an easier way, because a lot of people I think are sort of saying, let's wait and see, which again, not a great approach in my opinion, but it's an approach that people sometimes take.
Thanks. And I have another question here. Hello, everyone. My name is Cortez, and I'm a law student in the US. I was wondering how successful privacy protection laws can be if people, how successful privacy protection laws can be if people do not fully understand privacy concerns or what rights they should have regarding their data. Do you all think that there should be a mindset shift that is necessary for changing privacy laws to be most successful? And I know that this is definitely also a cultural issue. I mean, I know here in the EU, I'm here in Germany, but I grew up in the US, and it's definitely much more relaxed culture around sharing your data with online platforms and businesses. So what would you guys, what would you say about this and your response to Mrs. Cortez?
Maybe just to echo your point there, Sterni, I think this is so culturally ingrained issue. So especially in Germany, I think the history has really affected the way people perceive, especially surveillance. So anything to do with surveillance in Germany, I think, has been really impacting the overall public's perception, and everyone is sort of on the lookout for anything that might be potentially sort of going down that route, and everyone is very vigilant about it. Europe in general, I think we have had that experience of being surveilled, at least part of Europe to a degree. So I think we are a bit more paranoid almost to a point about the data processing going sort of in the wrong direction. With that said, I think that it also goes on with how people are tech savvy. How do they actually realize the data might be used, because the first argument I always hear from someone would be, well, actually, I don't care if someone reads my emails, there's nothing in it. But then again, as you go on to realize how the data actually might be combined and used against you, even if you're not necessarily plotting a terrorist attack, that's what might be an issue. Interestingly, for example, in United Arab Emirates or sort of Middle East, people don't really have the concept of personal data. It's fairly new to them. So they're very much on a different boat in terms of that journey. So culturally, very, very important. And I think as we sort of globalize the society, it is getting to a point where everyone is having that raised awareness around what's happening with their data. So absolutely, I agree with this sort of notion in the question that having that awareness definitely helps with getting privacy on the map with businesses, as well as regulators getting more bandwidth for enforcement.
Right. And I just like to add something small to that, is that I like to ask my friends, what level of discomfort do you have with it? So are you phone number? Are you okay with someone knowing your email? And usually people are, they say, okay, I'm fine with that. But what about your home address? And what about your social security number? What about your health records? And then they kind of get a feeling and an understanding of the different levels of privacy invasion that exist with data protection and data privacy in general. Preston, did you want to add something?
Yes, yeah, sure. So I love this question, and I would say I think like I'm very radical in this opinion. I think there needs to be some kind of shift in the U.S. To Linda's point, and Sturny to yours as well. Like there is a cultural difference, and part of my suspicion is that here in the States, we've got this concept of personal liberty and your own individual. And the best way I can describe this is, sometimes there are court cases around cyberbullying. And historically, that has not succeeded in the United States, because juries will basically say, well, hey, if you put naked pictures on the internet, that was your fault. Not that your boyfriend took it and sent it to the news. That wasn't, but it was, you shouldn't have done that. So there is this onus of, if you put data on the internet, that's your choice, it's your fault. And I think to the question from Cortez is, I don't know if there is that level of technical literacy where people really appreciate just how much they are freely giving up. I am one of those uber paranoid people. I'm the jerk in the grocery store that's like, why do you need my email? I've got cash, you've got food, let's do it. And I was hoping, like my brother is an IT person, and he was telling me it's just going to take one 15-year-old kid to hack the president's email, and then this whole thing will change. And so I think that's kind of, as everyone was saying, we for whatever reason in the United States, we just haven't appreciated the risk. Maybe it's just our historical experience or the cultural approach, but I would like to see more people be more careful of their data, how they use it. And what I always find is, I'm a geek on this. When you show people how easy it is to find that data, some people get freaked out. And my classic example, if you ever have a customer service issue, don't call the 1-800 number, find the CEO's home phone number. It's pretty easy to find on the internet. You call them, you leave them a voicemail, problem gets solved like that. And that's what's crazy to me. I'm like, you're the CEO of a multi-billion-dollar company, and it took me 10 minutes to find your home address, but it would have taken me 2 hours to talk to customer service. How wild is that? So I don't know how Carmi or others feel, but I'm very much, I'm to the point now where I might have to start lining my walls with aluminum foil or something, because I get scared about how much data is out there and all my passwords are hacked. And I'm just thankful I'm not very rich, because my identity is not worth stealing.
Right. I mean, as Carmi would say, it's not a matter of if, it's a matter of when.
Yeah, I just going to say what Carmi was going to say. I guess technology got us here, and technology can get us out. One of the, I don't, Preston, advise you try to live in a Faraday cage. It's not going to work, and so forget it. That's not it. The thing I want to bring about privacy and technology is actually a story, and I'm going to tell it from Israel. Is that we had some problems in the news where nursery school children were being abused by the staff, and so the parents immediately said, let's put cameras in all the nursery schools. So we can record, because these are 2-year-olds and they can't talk to us. Now, obviously, putting cameras on children with access to the internet is not really something that you want to do from a privacy point of view. That's like, it's up to your, number one no-no of things you really shouldn't do. It's like put babies live 24/7 on the internet. But on the other hand, the pain was they can't report it, and we have to get these criminals and they can't talk. And so technology solved the problem. They put the cameras, but they had stringent secure controls on the access to the data, and therefore the parents got what they wanted, but we don't have live streaming cameras where everybody can see what's going on in nursery schools. And so I use this as an example where the content, for sure, no matter what your culture, is something that you want to have controlled in this case. In fact, it's not a question of convincing you that these videos should be controlled. Almost anybody would agree that this is material that needs to be controlled. But on the other hand, as technology goes forward, we want to use it to give us more value. We don't want to have stigmatized children being beat up by their caregiver in their nursery school. And if we can stop it with technology, we're going to do that. And so that's where companies like us and many others commit to sort of bridge the gap between keeping your privacy private, but allowing technology to advance to do and help our lives become better. Okay. Whether it's cameras in almost every place. I think London, downtown London, you're totally under camera surveillance all the time. But the access to these cameras seems to be controlled enough so that the pain is worth the gain. If it gets hacked, there's issues like that. So I think that's where we need to keep being vigilant about making sure people realize their privacy, making sure people know that it's their data, and offering them the ability to control access to their data so that it doesn't get exposed to the wrong people.
Yeah, it's definitely a whole nother discussion if the pain is worth the gain for monitoring people in public spaces. But I think we have to wrap up here. And thank you everyone for joining us today. And thank you to our speakers, Linda and Preston. Thank you, Carmi. And we hope that you're all staying safe and healthy at home. And we look forward to hosting many more webinars like these. So to get in touch also with today's speakers, by the way, feel free to reach out to them directly. I'm sure they'll be happy to answer any of your questions. All of today's attendees will be receiving an email in the coming days with the contact information for each of our panelists. So don't be afraid to reach out, drop them a line. If you have any questions on, further questions on any of today's topics. And stay up to date on Hub Security's upcoming webinars. You can follow us on LinkedIn. We're also on Twitter. And you can also check out our weekly digest on Medium. Thank you everybody again for joining us, and thank you to our speakers.
Thank you.
Of course, yeah.